I'm Christopher Lonn with the law firm of Jennings Strouss in Phoenix, Arizona. This is the third part of a series of videos I've done concerning the FINRA securities arbitration process. The first video, which you may want to take a look at, addresses the commencement of the process. The second video addresses the importance of qualified securities counsel in handling these cases, together with discovery issues and the utility of experts in the process. This final video addresses how the process is concluded. So let's talk about the arbitration panel. The arbitration panel, as I mentioned previously, is made up of a chairperson along with two other arbitrators. You need two of the three, at least, to prevail as a claimant. Unlike traditional court, the arbitration panel in FINRA securities arbitrations are the judge and the jury rolled up into one. They determine evidentiary issues, they determine discovery disputes, and they ultimately determine the result in the case. In FINRA securities arbitrations, unlike traditional court, the processes for evidentiary rules are relaxed. Therefore, more evidence will be admitted and that the arbitrators will consider because of the relaxed rules of evidence. This does not mean that it is a free-for-all. It just means that more evidence will come in, and the arbitrators, as they have a great amount of discretion in these cases, will decide the weight to give to that evidence. At the close of the evidence, the arbitrators will allow the parties to make closing arguments. This is where your counsel will take the facts that were admitted into evidence and will argue inferences from those facts and apply it to the law at hand and the various claims that have been made in the statement of claim, which I referenced in the first video, to persuade the arbitration panel to rule in favor of the claimant and award damages and potentially other relief as requested in the statement of claim. Once closing arguments are concluded, the arbitrators will close the hearing and quite commonly will move to a location where they can deliberate as a collegial body for some period of time. Ultimately, the arbitration panel has 30 business days from the close of the hearing to render an award, to return it to FINRA, and for FINRA to then serve the award on the parties. The award may include compensatory damages, punitive damages if the respondent's actions are bad enough, and attorney's fees. A positive feature of the FINRA arbitration process, especially if you're a claimant who prevails, is that there are very narrow grounds for appeal, meaning that appeals are very infrequent in these cases. So if you prevail, the brokerage firm is likely not going to appeal, and then the award will tell the brokerage firm that they have 30 days to pay the award. And typically, these awards are paid within 30 days because the brokerage firm does not want to incur a sanction, which could include suspension of all business activity if the award is not paid. Therefore, awards typically are paid without much difficulty and without having to incur the expense of having your attorney enforce the award in a court of law. This is the end of the three-part series of videos on the FINRA securities arbitration process. I appreciate you taking the time to watch. If you have any questions about these videos, or you think you may have a case that might be evaluated, please contact me at Jennings Strouss.